Welcome. This is the Domain Name Law Show. We appreciate you being here. We're here every Tuesday, noon Pacific, 3 p.m. Eastern. Takes all my energy not to sing during that song. I'm dancing. I'm doing the hustle. You guys know the hustle, right? Do the hustle. Yeah, that song, that Lowdown by Boss Gags. Actually, more people are doing the hustle to that song than to the song Do the Hustle. But it's fantastic having people here join us for this exhilarating show about domain name law. Today we have a big show, so I'll get right into it. But first, I want to welcome all the guests here and then all the listeners. Thank you so much. And if you're listening on replay, man, you didn't have anything else to listen to? Hey, thanks for listening. And now I say hello to my co-hosts, Jeffrey Neuman and David Michaels. Hi, Jeff. How's everything going?
Everything is going well. Just dropped off my youngest at college, which is kind of weird. And then I take the older one in on Friday, and then I don't know what I'm gonna do with all that extra time. But yeah, things going well.
Yeah, like they would hang out with you anyway. But it is it's nice to have the kids at home. But I know what you mean. So then it really is like, geez, no, any sound you hear then, must be the dog, right? I mean, because nobody else
Yeah,
is
well,
around.
we always blame the dog anyway.
Um, hey, David, how's everything going in your area up in Canada?
Oh, it's fine. A little rain finally. First rain we've had in months, so it's good.
Well, we're going to get rolling today. We got four cases we want to review, so we're going to try to get to them quickly. So the news that we're going to touch on, if you want to check it out, you can go to DNL Show. That's domain name law, DNLshow.com, and click on outline, or you can go to dnlshow.com/outline, and boom, right there it is. Whoop, there it is. And basically, today, the very first thing on the outline, we're going to blow through the domain industry news. The last item, well, we'll try to touch on, the new registration data policy, but it's not there's not a lot of information. Anyway, let me get to the first news. B1 on the outline. I fell for a fake online store. I should have noticed the warning signs. That was Andrew Alleman at DNW. If you don't go to dnw.com and check out his daily blog, do it. He's got articles, usually two or three, sometimes per day, and he also has a podcast that he interviews all the top folks in our space, and sounds a lot better than a lot of the things that I do because he slows it down and cleans it up. I like just do it live, no editing, then we'll see how it goes. Right? Okay. So anyway, he said he fell for an online store. In a nutshell, he was buying some, I don't know, some supplements, some not for a diet, but for his dietary. I don't know what he was buying, but he said he buys these supplements every twice a year. So he couldn't remember the exact domain name, and he just searched Google for this brand, and he saw, well, damn, there's an ad, and they have a sale going on right now for this particular, whatever it was he was buying. So he clicked on the ad, bought the pills, but basically put his credit card number in, and then it said your credit card was declined, and he thought that's weird. And then he looked and he saw it was a .store domain name, and he thought, hey, the place I used to go with, they didn't have their exact match of the supplement, but or maybe their company name. He didn't mention it, but he said, I remember it wasn't a .store, it was a .com. So he immediately looked to see when the domain was registered, and he realized, oh, like a few days ago. And then he he went to Google, and I didn't know you could do this. He went to the Google ad, and apparently you can click on the three dots next to the Google ad, and it tells you who paid for that ad, which I was never aware of. But anyway, so he found out it was a Chinese registrant recently registered the name, and he found out they paid for this ad. And his credit card or his cards, he said, hadn't been used, but they probably just collecting the data and end up selling it to somebody else. So I think he made it out alive without any charges. But um, David, first, I want to ask you, have you ever heard that? So you can click on, I didn't know, you click on the Google ad and you can find out who paid for the ad. You ever use that feature?
I use that
Uh,
in my Google AdSense review panel because obviously there's a lot of advertisers out there, and I try to clean them up because some of them are not above board. And Google doesn't bother. So I wish they did. It's a hassle.
Yeah, and I don't necessarily do that for ads, but I certainly do with emails, and we'll talk a little bit about that when we get into one of the cases.
Okay.
Oh, I think we might have. Did we
No,
lose
no,
Todd?
we didn't
There
notice.
you are.
I don't know why when I stream live on YouTube, and we've been doing it just so I don't know if anybody listens there. It does slow down my computer. This MacBook Air that I do this show on, and I'll probably go back to my Pro. But anyway, so that was just coming off mute. But anyway, interesting that I like that Andrew over at D&W was just saying, hey, it gives you an idea of he's normally news articles about the industry, but he was saying, hey, it's not anyone, even if you're familiar with domain names, you're in a rush, you're on mobile, you can make mistakes, but be careful out there. And I noticed when I got some money stolen from me a few years back it was basically Web3. It was NFT bullshit, but it was if I would have looked at the domain name, that I would have known it was fake. I was just in a rush and didn't take a look. So always, it's not always works, but because somebody could actually steal a domain name and spoof you that
Well,
way.
yeah, and right now, look, you got to think about too of this in the context of Web3, right? At least in Web2, you can cancel your credit card, you could stop the payment, you could claim fraud. There are remedies by law, but you know, um, if you initiate a transaction on Web3, it immediately goes through, and there's no remedy for you. So this kind of thing is just going to get more sophisticated, and people really need to pay attention, especially if they're dealing in crypto.
Yeah, and you say no remedy in Web3. There's companies, soon as they realize you post, especially here on X, I've been robbed, somebody, drained my wallet. There's tons of people that say there's a remedy here, click here and go to this. And they're just almost all more scams. I'm sure there's somebody out there that tries to help track down things and see if they can find out who did it to you. I don't know what their remedy would be, but yeah, that's just a big scam. As soon as you get drained in Web3, there's so many people that are like, "Yeah, you need help now," and you're panic and frantic. So you then go to somebody else who scams you again, kicking you when you're down. On B2 on our outline, B2, that's our news section. I mentioned Elliot talks about checking on LTOs. So Elliot Silver, Domain Investing, was saying, hey, if you're going to offer your names on lease to owns, you need to check just every so often for a couple things. One, you want to make sure there's not selling counterfeit goods or illegal substances, or they're infringing on someone else's trademark. Basically, it's your name. Check it out. And he also mentioned if you see that the site's down, probably you can probably expect more likelihood that they may end up not completing all their payments if they're already out of business. But Jeff, when you hear about LTOs, what is the biggest risk that comes to mind to you?
For whom? For the seller of the name, or for
For
the buyer?
Jeremiah, who's just sitting out there random. No, for the seller of the name.
Yeah, well, I mean, you know, the seller obviously is, and I think this came up at least once. If the buyer does something with the name to lose the name, then the name has to be transferred, like through a UDRP or whatever it is. And I think some owners or sellers have been um, putting provisions in there that if that happens, then you owe all the rest of the money up front. But good luck trying to track down the buyer and charge that buyer. It's not always easy to do. So yeah, I mean, I think that's how someone uses the name that you are leasing is pretty important and risky, or can be risky.
Yeah, no, good point of really it can be the seller or the buyer, and then the seller can do things to get you in trouble, legally with a UDRP or let me say that's not, if you want to call that legally, but through that hearing or possible civil lawsuit, but certainly criminally too. Not you, but they could do something criminally and jeopardize the name. David, do you give any thought to this, the LTOs and what risk either party may run into?
Well, we had a similar case about this, like we talked about like maybe 3 or 4 years ago, involving um, some brand. There was a lawsuit in Utah, and the owner was in California. It was like a oneword.com. And it turns out there were this, they got embroiled in this lawsuit in Utah, and I think there was an order for transfer in the federal lawsuit. So that wasn't fair. I don't know how it ended. I think it was involving like an online learning company. Can't remember which one it was. But anyway, it's a problem. I have in my lease to own or installment payment contracts, I actually have a provision in there saying that I can take back the name anytime if they're using it inappropriately, especially if they're like violating FDA rules or whatever. Um, that's an important term to have.
That's a
But I
private
don't think any of the
LTO
standard
agreement.
agreements had that, like, especially with Dan. I was looking at Dan's old agreements back then, and they didn't have that provision. I don't know if GoDaddy does.
Yeah, and now I'm hearing that Seller Hub over at Spaceship is going to be offering LTOs with no limit on the price. So GoDaddy after Nick has a if the price is over 100 grand, so some people were pricing their names 99,999, which then allows for LTOs. If it's 100 grand or above, apparently after Nick doesn't. I didn't even know because I didn't price them that way and request that LTO be offered. But so yeah, it sounds like Seller Hub is a new player in the LTO game, new player in the marketplace area, and yeah, it'd be interesting. We'll take a look at their LTO agreement. I mean, if anybody has included a lot of things learning from the past, it would be this Seller Hub. So yeah, a lot of news. We're going to be talking about Seller Hub, and I think I'll formally invite Richard in sometime and just casually just saying, hey, drop in on us on Thursday. He'd be a good guest on this show too to say what legal issues does he run into operating Namecheap and Spaceship. You know, in addition to, I mean, basically outside of UDRPs and that type of thing, just as a businessman running your company. He said he's got 100 engineers. Well, how many lawyers has he got? At least one, right? Two or three, four or five. I mean, they do something. You need them to protect you. But I wonder, what are they protecting you from? You know, what basically legal issues do you run into? But anyway, on Thursday with Josh, that's 10 a.m. Pacific, 1 p.m. Eastern here on Spaces. We're going to be talking about Seller Hub and the new platform. A lot of talk about it. I mean, I'm seeing some domainer friends of mine that are checking it out and trying it out. So, and I just listed 1,000 names over there. Of course, still got them listed at, old. I'm not going to say old faithful, but old standby GoDaddy after Nick, because I certainly wouldn't just jump off one boat and go to the other, but definitely want to try out both. So, yeah, check out me and Josh's show on Thursday. We're going to be beating up everything domain investing. The third thing I had here on the news, yeah, Adam introducing trademark.io. It's really a standalone tool, so you can go to trademark.io. And I did and was searching some the things that I'm involved with, companies, and I was searching to see what other trademarks are out there and so on. But David, I think it's going to be a pretty cool tool. I'm glad somebody's offering it. I mean, it can't hurt, and I'm really somewhat impressed with what I've seen so far because I'm not paying for anything. But have you checked out trademark.io offered by Adam now?
I have. So it is using an Elasticsearch, so that it'll pick up names that are not exactly matches. So I typed in a couple of my own domain names that had and they found different spellings of trademarks that were out there that were recently filed. So that was interesting. I don't like the fact that it doesn't give you any links to the actual trademark files, and it doesn't say which country that trademarks are with, but I went to the USPTO and verified that those are USPTO searches that's giving you, but it doesn't say that. It doesn't link to the USPTO TSDR file. That would be very helpful. It doesn't let you export the results, so that's a problem. You're just better off going to uspto.gov and doing your own search directly and then export the results and feed that through your AI system.
Have you had a chance to
But hopefully
check
they'll
that out?
improve it.
Go ahead. Have you seen it, Jeff?
Yeah, I agree with David that it's not quite, to me, doesn't seem quite ready for prime time. But I could see them developing it and using AI to have it learn. The part that I'm always leery about is the fact that uh, the attorney work, like the trademark filings, the package that they offer, which sounds cool, and it's like a thing I guess LegalZoom does. But I'm always leery about who does the work and whether they know what they're doing. Um, there's a lot of fees that are involved, which most people won't know about unless they read the fine print. But again, yeah, if I were to ever want to use a service like that, I would need to know, okay, who are the attorneys that are working on this? Are they even based in the United States? Are they just cheap labor? How much do they really know? All that kind of stuff. But the tool is kind of cool, and I think it'll keep getting better. But I'm not sure I would ever use the filing um, service.
Yeah, the good point, Jeff, and I felt the same way. I didn't spend a lot of time at trademark.io. This is we're talking about a new standalone tool that Atom, ATOM, formerly Squad Help, created, and now they've launched it. And two things. One, yeah, I want to know, well, list the 3 lawyers that help, or the 10 lawyers, or who they are, or the firm. But I mean, it's not just a
And in the
jumble of,
United States,
yeah.
you're actually required to list and provide background about the attorneys. Like it's um, there are some ethical. I know it sounds funny, lawyers and ethical rules, but yeah, we do have them. And you're really supposed to be much more upfront and much more in the way of disclosures when you're providing legal services, even trademark filing services. Those are legal services, and I just don't see any of the required disclosures up there. So it almost leads me to believe they're not U.S. attorneys working on it, but I could be wrong.
And when you do, I'm certain, and I haven't, investigated it completely, but when a company or a platform like trademark.io starts offering services to where they're going to help you assist in filing your trademark application, well, they probably have a trademark um, monitoring service too, I'm guessing. And then, when lawyers say they're going to offer comprehensive trademark search and monitoring, well, comprehensive, that's a key word there. And a lot of firms I know from a few years back, yeah, they had to remove some of the words. If you're just doing some general search, not something truly comprehensive, you can't say comprehensive because I mean, anyway, it's really important what type of work that they're doing, what kind of search, what kind of monitoring, who's filing the application. So set that aside. I was going to mention, I use dntrademark.com that my partner Chad created because it can allow me to get notified. And I'm sure trademark.io probably has some notification too, where if you're tracking a name, your name, you own a name and you want to know who files anything subsequently. I've owned this name. People many times will start filing subsequently to it, and it may be of interest to you because then well, who may be interested in the name, but also what categories, what classes they plan on using that domain in. And many times if it's a name that is really descriptive a little bit, they likely shouldn't have an easy time getting a trademark for it if it's truly descriptive, but you may want to um, file a, I always forget that word. What is it, David, when you try to stand in the way of them getting their trademark? It's a
You can file a letter of protest
protest.
before
Okay.
examination, or after it's allowed, you can file an opposition.
Okay, opposition and protest. I'll remember that. OPP, you know me. Hey, all right, so we'll quickly get to this last topic so we can start our cases, but this last topic is important. Amit brought it to my attention. He said basically I knew about it, but I wasn't going to put it on today's show outline, but we'll touch on it. So this Thursday, registration data policy gets updated. In a nutshell, and Jeff, I'll let you touch on it, but in a nutshell, to me, the only thing I see that's really that means something to me or easy for me to understand is okay, if I have a organization name, that's going to basically supersede the registrant name. If I have an organization name, they're going to consider the organization as the registrant, and then that's on new registrations. But on say my existing registrations, if I have an organization name like American Business Capital, my registrar is supposed to confirm that with me or remove it. Basically, so the point is, if you have an organization as your registrant on new registrations, that is considered the registrant, not the individual. And then, of course, no longer billing. I believe it's, oh, no, no more billing or admin contacts, and technical contact is optional. That's the highlights that I see. But, Jeff, what should we know about this new policy?
Yeah, I think your summary is fair. I think a lot of the policy is done on the backside or the back end. So, registries are going will have a choice, and most of them are electing to do this, to only collect certain information from the registrars. It's called the limited data set. So, registries now in theory collect the admin, billing, all of that stuff, registrant name, um, which has been pretty useless in the past few years anyway, because the what the data the registries are getting is just quote redacted for privacy. But in cases where that data was actually provided, registries, most of them are going to opt for the limited data. So registry at the registry level, they're going to look. A lot of them, like .hip hop, will look more like if you went to VeriSign and did a Who is search. Um, it's just going to produce the minimal data set. The IP addresses, the registration date, the registrar abuse contact. Um, very limited information. So that's part of it. The other thing is to the extent that uh, you're giving data to ICANN, you can require ICANN to sign a data privacy uh, agreement. And so, like I said, most of it's on the back end. There's some new things with privacy things with transfers, but most people will not see that.
David, do you have any interest in the registration data policy, the new one that comes into effect on Thursday?
I haven't really understood what's going on, what's changing. So I don't know yet. We'll find out.
Fantastic. We'll get to the part where everybody's been waiting for. And David, look, it's 12:24 my time. It's 2:24 your time. Is that right? No, 1:20. What time is it? Oh, it's 3:24 your time. So we've made it. Before 1:25, we're going to get to our cases. This is the moment you've all been waiting for. The very first case, I'm going to really have Jeff explain it, but Jeff, I wanted you, so this is a case that Jeff just decided. If you guys don't know, our own attorney, Jeffrey Neuman, is also a panelist for the forum. He does do some work at WIPO as well when it's a 3-member panel, and he's requested to be there. So this domain name is IBM-tech.us, IBMtech.us. So Jeff, I wanted to really, I've never asked you this before. It's pretty personal. No, I wanted to ask you, so tell us about the time you receive it via email, what your first steps are, all the way leading up to you submitting the decision like you did today to the forum. So tell us your whole process, and then of course include in this case, the facts of the complainant, the respondent, and how you decided. Thank you.
Yeah. So 2 weeks ago, I received a file from the national, or sorry, I still call them after years the National Arbitration Forum, but they're just the forum. I received a link to get all of the materials that the forum had on this case, which is the complaint, the amended complaint if they chose to file one, all of the exhibits, a response if one has been submitted, the verification email from the registrar that says, yes, indeed, this name is registered by so and so, and here's the real contact information. Um, and in this case, there was not, there was a response. But then 2 days after, or maybe it was even the day after I got the case, we get a note, the provider gets a note from the complainant basically saying, um, we're just putting you on notice that we may ask for a stay because the respondent, and he forwarded the email, the respondent put in their response that they agreed to a good faith transfer in exchange for the price that they paid for the domain, which was, they indicated, under $20. And so the complainant was like, oh, pretty cool. Okay. So the complainant said, we're just going to confirm this. And if it's confirmed, we'll ask for a stay and, for us to do a settlement. So, at that point, I paused any review that I was doing. And since it was only the day after, I hadn't actually read any of the file, which so it was fine. But then 2 days later, we get another email from the complainant saying, no, forget it. It turns out the respondent's not interested in transferring the domain. Um, And in light of what was in the original response, which clearly, and I cite this in the decision, the response had a paragraph that said, and I quote, good faith willingness to resolve. Respondent is prepared without prejudice to voluntarily transfer the domain to complainant upon reimbursement of out-of-pocket registration costs, in parentheses USD under $20, to avoid further proceedings. This offer is made solely in the interest of efficiency and is not an admission of bad faith registration. Inexplicably, in the next email, the respondent said, I never said that. I don't know what you're saying. I said I had every right to use the name, which, to be fair, there was more to the response, right? The response did go into his arguments as to, and we'll talk about that in a second. It did go into his arguments as to why he thought the registration was legitimate, but it ended with this good faith willingness to resolve, and then it was signed with, the normal certification, which basically says I declare under penalty of law that my response is true and accurate, and so on. So that was kind of interesting to me. I'd never seen that happen before, and kind of makes me think of how could a respondent. I would understand if the respondent said, change my mind, right? That would be one thing, but the respondent just blanketly said, no, I didn't say that, even though it's in the same email chain where he said I didn't say that. Anyway, so right away now, I'm kind of distrustful of the registrant because of a clear and blatant lie. So, but the facts of this case are pretty standard, right? This name IBM/tech.us was registered, and not for that long of a period. The IBM, the famous mark owner, went after the site, and the respondent said, no, I have every right to register this name. I registered it because, to me, it's a personal slogan that means innovation beyond machines, and I intend to use it in connection with um, a site devoted to technical essays, and that was the explanation. So obviously they have IBM has rights in the IBM mark, and so the first element was pretty easy. The full trademark is in there, and it's confusingly similar. The second element, rights or legitimate interest. So the complainant basically does its prima facie case, says I never licensed the use of my mark to the respondent, and the respondent is not known by or commonly known by the IBM mark. Well, interestingly enough, the who is information or the registration data states that a company called IBM US LLC is the registrant. So you have to go one step further and say, okay, well, just because the name is in the who is there any evidence that this person is commonly, or this company is commonly known as IBM? And the complainant submitted evidence that there's no company in California that's registered that's named IBM US LLC. Um, and, there was no evidence submitted by the respondent other than, it's the statement they made that it's a personal slogan. Um, so right there, as the panelist found that it's just not a credible explanation. It just very much seems like someone who registered the name and then afterwards tried to come up with some acronym that met what they thought would be a good excuse for the respondent. But clearly, it just there has to be some evidence other than um, some evidence of demonstrable preparations to use the mark in order to find that the registrant has rights or legitimate interests, and there was none. So I found that the complainant succeeded in that element. And then the last element of registration um, in bad faith, or this is a US TLD, or sorry, .us, top level domain, that is, you must either register or use the name in bad faith, not just, not what is normally in the UDRP, which is a conjunctive. You have to do both. It has to be registered and used in bad faith. So here, because of the non-credible information that was provided by the respondent, because IBM is clearly a famous mark. And I forgot to mention um, how the registrant was using the name was just pointing back to IBM. So that's a classic, using the name to pass off or to make people think that you're affiliated with the domain. So I found that they met the third element. But where I think the interesting component of this case is that the complainant alleged that the domain name was being used, or sorry, that the registrant had configured email servers, and therefore it was likely to be used or could be used for phishing emails. And there was no other evidence. It just said that, it was upon information and belief, it was being used in phishing emails. And the second argument they made was that the complainant made was that the domain name's IP address was associated with other domain names that were used in the distribution of malware, and then guilt by association. Therefore, this this domain is likely being used for the distribution of malware. Um, I rejected both of those arguments. Right now, the complainant didn't need these arguments to win the case, but I went into some detail about the fact that, look, if you're going to allege, you can't just allege upon information and belief. Number one, you have to prove your case. Number two is you can't just allege phishing and not provide any kind of proof, right? That's just not going to be accepted, or shouldn't be accepted. And we'll talk about other panelists in a second. And then the last thing on the malware. So I went to MX Tools, which is a free reverse IP address lookup, and found out, well, yeah, this domain is on an IP address that's associated with other domains that are being used for malware, but it's owned by Amazon Technologies, AWS, and associated, it's linked to 6.7 million other domain names. So yeah, of course, there's going to be some domains on there that are being used for malware, but there is no guilt by association. Although the complainant cited some cases where other panelists did find this guilt by association, and other panelists found that they just accepted the allegation that it's being used by that because there's email servers that are set up that it's could be used for phishing. And so I basically rejected other panelists' decisions that made that determination, and also said that you need to have proof. And yeah, so I think that's the more interesting component of this case. And I hope that other panelists, education is really needed for other panelists. They can't just, and there are cases that say this, unfortunately, that if you have email servers, that it's likely being used with phishing. Or, I suspect other panelists may have fallen for the fact that, yeah, this IP address is associated with malware because it was in a report that the complainant provided. I went and did some extra research because in the report it said it was owned by Amazon. So that kind of tipped me off to say, well, likely this is not the only domain. Um, so, and that's where I found out that on MX Tools that there were 6 million other domains that rely on this IP range. So my guess is that a lot of panelists wouldn't have done that research and would have just accepted the arguments. Here, again, it didn't affect the outcome of the case, but in other cases, you clearly see it affects the outcome without panelists doing any sort of research. And I hope, if anything, this case kind of gets reported on and talked about so that panelists know that they shouldn't, there needs to be actual proof and how to find that actual proof. So sorry I went on a little long there, but yeah, that's the case.
Well, good. And David, go
Interesting stuff,
ahead.
Jeff.
What comments do you have on this case? And say the name again.
It's ibm-tech.us. So I looked it up in MX Toolbox. Yes, it is using Google SMTP servers. And I looked at the who is information, and it's using GoDaddy's domain control DNS records. So are there some domains registered at GoDaddy using domain control that distribute malware? Malware, probably, probably more than a few. I see a lot of scams coming out through GoDaddy's registration stuff. But anyways, yeah, it's interesting. So I clicked on check SMTP, the SMTP test, and the DMARC doesn't resolve, the SMT banner check doesn't match. It gave me some weird TLD using a weird domain name using numbers and a .net. So I don't know what's going on with that. Didn't think that Google does that. So maybe this is something that GoDaddy set up automatically and it's just not configured. So I don't know, unless there's an actual email coming from it, I have no way of knowing. I think I heard recently that GoDaddy switched over to Google Mail services, but I might be mistaken.
I think GoDaddy is going to use Titan. I think that's what they're planning on selling. But
Titan.
but I don't know if they also offer Google stuff. I do know that GoDaddy does, for a lot of its domain registrations, goes through Amazon. Um, or sorry, wait, GoDaddy. No, sorry about that. Amazon goes through GoDaddy, and GoDaddy goes through one API to do some domain extensions. But yeah, I mean, look, I didn't go that much into the name servers because the complainant, didn't submit any information of phishing, and so I was like, yeah, I'm just going to disregard the argument. But on the IP address, the IP activity report, which the complainant submitted, which also was done through IBM, its own service, said, you know, had this report that there were other names that were associated with malware, but the report didn't say there were 6.7 million names that shared this IP address range.
In this
Yeah, that's pretty
case,
egregious. I think deceptive. They shouldn't be doing that. They should be more accurate.
Yeah, I agree. It's deceptive, and I agree, and I think there's a lot of panelists that won't do the research, and you know, kind of coincidentally, not coincidentally, because I actually was polling some other panelists when I first got this case, just saying asking how many of them do. Um, Even like if someone submits evidence of phishing, like an email, do they look at the header? Do they look to see whether it's spoofed or not? Um, I didn't have to do that in this case because, again, I didn't get the complainant really didn't submit any evidence of phishing, so I didn't have to do that. But in a lot of cases, email addresses can easily be spoofed. Um, and I think it's in one of our cases today, right? I've read a lot of cases today. So I think one of our cases, there is a spoofed email or things that we believe may have been spoofed. And I think it's the Regions case. I think we'll get to that one. But most panelists have no idea how to check for whether an email is being spoofed or not. And two, they wouldn't even do the check even if they knew. Um, and that to me is something that I think needs to change. That if a complainant is going to come forward and say an email is being used for phishing, it needs to prove that it's actually being done by the registrant and not being spoofed by someone else.
right, and you're right. It is the Regions case. We're going to get to that. And what he's talking about, phishing, spoofing with fish. Right, you get an email from a place that says it looks like it's coming from regions.org, and we're going to see that in the cases two down the road here. But you don't know that regions.org, that domain owner, that registrant, is responsible for those spoofing emails. Many times, somebody that's phishing with an email tries to use a reputable or an authoritative looking email. So they do that. That's very frequent. That's why Jeff's saying then you look at the records and see, did it really come from that email address, or were they just spoofing that domain name to make it look official? Well, interesting about your case, Jeff, and I'll say sort of interesting, was this respondent. So the domain that Jeff ruled on, ibm-tech.us, okay, IBM Corp, the big one. And I thought it was interesting. I didn't know IBM's been around since 1880s. There was no computers back then, but I guess they did records. They helped people sort bullshit. I have no idea. I thought, IBM, the computer company, and they came up with it. Must have been a big computer in 1950. Must have been massive, huh? And then Apple said later on, a couple decades later, we'll show you how to do this. And but anyway, so IBM been around since the 1880s. But they're, of course, the complainant here. This respondent said, well, my company, Innovative Beyond Machines, that's what IBM's now. Well, right, they need to show, if you are goofy enough to name your company that, well, let's see some paperwork. Let's see some business that you've done. Let's see some activity. Let's basically see it. We're not saying that you weren't doing business as Innovative Beyond Machines. What I thought was interesting was the respondent was, like you said, Jeff, contributing, basically responding, and said, hey, you want the name, you can get it for less than $20. And then reneges on that offer and says, I didn't really.
Well, it doesn't even renege. It's
Yeah.
not like that would be one thing if it said, you know what, I decided not to. He just said, I didn't say that. What are you talking about?
Yeah, he must have been. I didn't say it in that fashion, but you're right. So this respondent, but the respondent did on his behalf say the reason why I have updated those MX records is because I wanted to make sure I got proper notification from my registrar, but this wasn't for customers to use. So basically trying to defend himself with regards to the phishing and setting up the MX record. So it was weird. Yeah, the respondent is, trying to answer and defend themselves, but then make some mistakes by basically lying to you. But then this complainant reminds me of an amateur, and this was IBM Corp with their lawyers, an amateur lawyer that's filing the complaint. It's okay. Lawyers often load up on evidence, but usually it needs to be the same, relate to the same, I don't know, the same facts or the same thing that they're trying to prove. In this case, when you said, they throw a bunch of shit at the wall, and you're like, well, you don't even need to put that in. You don't even need, that doesn't make sense, that about the configured for the using the emails, and you have no no proof of it just by, like you mentioned, AWS. So a lot of companies, use that. It doesn't mean, and obviously there's going to be such a big provider that there's going to be spoofing companies. There's going to be illegal action that's, through that service, that provider as well. But anyway, that case, so Jeff ruled a transfer. That was 1, 2, 3. IBM had the trademark. 2, they did successfully show that this registrant didn't have really a legitimate use of it. He could have showed some stuff, but he didn't show no bona fide use. And Jeff used those words that we're going to use in the next case of preparing any preparation that he made to use it in this, legitimate way. And then, of course, Jeff also decided that was registered in bad faith, which was really just a year ago. 9/2/24 is when the domain was registered. So right, less than a year. But yeah, so there's more. It seemed like just a straightforward case, but there's always more to it. This next case, I like this case because I've talked with Charlie about it, who's the panelist. Really like Charlie. I like this case because when I first see it, I'm thinking this is probably a clear-cut case of cyber squatting, probably a pretty easy transfer, but this wasn't the case. So this next domain name, Chick-fil-A-menu-prices.com. So that's CHICKFILA. That's like Chick-fil-A, like fila. It's like the shoe. No, Chick-fil-A-menu-prices.com was registered last summer, July 11th, 2024. So Chick-fil-A, who's owned by a company called, or I guess Chick-fil-A is the company, CFA Properties. I don't know. They're out of, what state are they out of? I had it there. Oh, is it? Oh, damn, I can't even read my own writing. Why does it say GD?
Well, the lawyer's in Georgia, but
Okay, GA. That's right. It was Georgia. I knew it was. Okay, so versus Muhammad Hamza, a Pakistani registrant. But anyway, you guys will find this interesting because well, first of all, you can have 2 complainants, and in one of our cases we have 3 complainants because is as ruled by Charlie here. It's Charles Kuchenmeister, if you want to know his official name. But Charlie said, if there's sufficient nexus to connect these complainants, you can have more than one complainant in a case. And usually that comes in when you have like an owner of a trademark, and then they license out that trademark to someone else. So really both of them have a right standing to go after. And in this case, there were 2 complainants. Charlie said, that's fine. And I didn't even realize that Chick-fil-A been around, using that trademark 50 plus years, Chick-fil-A. So the complainant said the respondent was using, PPC on page, and the respondent didn't reply. So they just went with the standard, hey, we didn't authorize them to use Chick-fil-A in their name. They're not known by Chick-fil-A. They went, did the standard, like Jeff says, prima facie case. So when a complainant makes this case that there's really, all this about no legitimate use, and we haven't, authorized them, and they're not a reseller to us, no relationship to us, and they're not known by this, then you really need to respond as the respondent. I just said the respondent didn't respond in this case. And so I'm automatically thinking, okay, it's not looking good for the respondent. They got Chick-fil-A-menu-prices.com. It's clearly in the domain name they're using Chick-fil-A. If it really came down to the landing page was I guess it wasn't a PPC page. It was showing, the menu from Chick-fil-A, and some of the prices were inaccurate, but Charlie felt like, no, this person was not really trying to make money on this website because there's only a few PPC links in many, many pages here. Now, there's more to the story, But before I get to it, David, I don't. You can share the rest of the facts and the decision because there's some things I want to go over here. But keep in mind, Chick-fil-A-menu-prices.com is the domain name. Chick-fil-A is the complainant. This Pakistani registrant didn't respond, and David, take it from there.
So I went to the domain name and it resolves. It has a disclaimer at the top in bold letters. Disclaimer, it's an informational site about Chick-fil-A. We are not associated or affiliated with Chick-fil-A officials. So something similar is written at the bottom of the page. It's a really long page. What I was impressed with, this is a new domain name, and it already ranks for 7,096 organic keywords. It's getting approximately 1,822 SEO clicks per month. It dropped by 1,300, so it was getting more before. It has competitors. There's Chick-fil-A-menus.com. It's number one in the space. There's Chick-fil-A with a double A-menu.com. That's number two in the space. It's just so much competition in these informational sites. You hear about these kind of sites sometimes on niche pursuits, and sometimes they say, okay, which places have Starbucks or ice cream at McDonald's? People do monetize them; they do make money from them. But yeah, so he had this disclaimer. He tried to do a good job, but one of the comments I read in the decision was, "Oh, we don't have a prices the same everywhere, and we don't have the ingredients the same in every location because whatever, we have different prices, and I guess it's different regions of the country have different tastes." And so there's no consistency. And so for them to say this guy's lying and putting false information on the website, I find that weird. If I'm going for nuggets at one location, it should be the same nuggets I get at every location. Whatever happened to standardization? But I guess Chick-fil-A doesn't believe in standardization. What did you see in this case, Jeff?
Well, the part that it's different pricing and different ingredients, it is kind of weird, but I mean, it does, that's pretty typical. But look, um, I really like Charlie's decision, and we haven't said what the decision is yet. Um, essentially, well, I don't want to go there yet, Todd. Are we ready for the decision, or? Um, but
Go down prong one, prong two, which because I think's interesting what you
okay.
said about the prima facie point of prong two, how he decided, and then going to the third. Go ahead.
Sure. So with the trademark, obviously, um, that's a pretty basic analysis. Of course, Chick-fil-A or CFA Properties is the owner of the Chick-fil-A mark, and because the mark is in there in its complete sense, that the domain name, which just as the terms menu and prices, is going to be found and was found to be confusingly similar to the complainant's mark. So that was, pretty non-controversial. Um, the next part was legitimate rights or legitimate interests, and Charlie went into a lot of detail here, and he basically said, well, you know, it's an informational site. Um, and there's really, yeah, there's a couple places where there's uh, potentially some PPC links, although one ad it was an ad for something, but it didn't have a link to that, so it's not, they're not really getting any revenue from that, probably. But the other thing is that there was a disclaimer, I believe, in pretty clear language that said, we're a food lover of Chick-fil-A. Our mission is to be your go-to source for all things Chick-fil-A. Um, Basically saying we're not Chick-fil-A. We're just fans of them, and that this, we're not claiming any rights to this at all. And so that's important when you're looking at whether something's being used for uh, the bona fide offering of a good or service. And then there's, then he balances the fact, okay, well, you know, we don't think it's being, phishing wasn't proven. Again, this is another case where the complainant just alleges that because they have an email configured that it could be used for phishing, and it's got something on its website that says if you want to get our newsletter or contact us or something like that, just fill in your name and email address. It doesn't solicit any credit card numbers or anything that a normal phishing site would do. So they said there's no phishing. Um, but because there was some um, discrepancies between the true ingredients and prices and stuff like that, um, they said, well, the respondent, um, we're not going to find that the respondent has rights or legitimate interests in the domain name. Uh, but that's okay because we get then to the third element. And the third element is registration and use in bad faith. Um, and for that one, Charlie says, look, yeah, there's some PPC links, and yeah, there might be some misinformation on there, but there's no intent being shown of being malicious. There's no, um, yeah, the PPC links, to the extent there is any revenue derived from that, is so insignificant, and so out of the 115 pages or something like that of the website, it appears on very few of them, or two instances, I think. Um, and so, because it's not a main part of the site, there's no real evidence of maliciousness. The uh, and because at the end he says, look, this policy, bad faith, means that there has to be some intent about being malicious. There needs to be some knowledge that the misinformation that's being put out there is known by the registrant to be misinformation. So, because that's not the case, or at least the complainant didn't show that, Charlie found that the name was not registered and used in bad faith. So, ultimately found in favor of the respondent, and the respondent got to keep the name. To me, great analysis, the right analysis. What worries me is that very few panelists, I think, would go into all this detail and look at all this, especially when the respondent doesn't respond. I could easily see some of the panelists that we've talked about in the past many times, especially in a default case, where, you know, they would just take the information as alleged and find that the misinformation and pay-per-click links are enough to find bad faith and would have awarded the domain to the complainant. I know that some of the panelists would do that. And so I really appreciate the work that Charlie put into this.
Yeah, and for those, I've mentioned it before, Charlie Kuchenmeister, he has always mentioned to me, I don't listen to much of what's written. I look at the evidence. So people can make all these claims, but he wants to look right at the evidence. So if you get a panelist like this, it's all about what was submitted as evidence. Of course, your wording, your claims can help clarify and make it simple for the panelists, but he looks at the evidence and um, solely, so that's why many times if someone doesn't provide information about their trademark, or if they're claiming a common law mark and they don't provide information, he's like, you can say what you want, I won't let it pass. And this, what was really interesting to me, Charlie said he looked at all this stuff, was writing down his decision, then he slept on it overnight, and he said he could have went either way, but like we said with the number one prong, yeah, Chick-fil-A has a trademark, okay, that's done. He said they did make a case that this respondent didn't have legitimate interest. They made some mistakes in that case, but the respondent did not reply. And when the complainant makes a case, we're going to go with a lot of the things that they've said if they provide some evidence, and they did for some of the things. And if there's no reply, well, sometimes you default to, okay, we're going to say the successful was complainant in that second prong. Basically, the complainant was successful, showing the respondent didn't have legitimate interest. It didn't make a bona fide use of this thing. Now, that was on the fence there, but what was unusual, usually when they find that, the bad faith registration and use, usually, I mean, is easier to find. But basically, Charlie said, and Jeff mentioned it, there you send me no evidence to prove bad intention when this person registered this name, which was last summer. So when they registered it, in one thing that would really swayed Charlie, I think, was the website promoted Chick-fil-A. He felt like the registrant likes Chick-fil-A. He's promoting your stuff. Who cares that, he had some prices wrong? Like David said, you guys aren't consistent with your pricing. You guys aren't consistent with your ingredients, so you couldn't expect him to have it all right. But if you get the gist of the website, the guy was, promoting. He was all for, basically he was all for you guys. So anyway, it ended up being complaint denied. So weird. If you look at it on the surface, Chick-fil-A -menu -prices, you're probably thinking, who would register that? You're going to get it taken away. When we're in our domain investing rooms, yeah, we see somebody register that, we're yelling at the guy. We're throwing tomatoes at the person. Okay. Because we're like, what are you stupid? What's your story? But I'm a fan. I'm a fan of Bruce Springsteen. I'm a fan of Chick-fil-A. So you really do have rights, and this person didn't even respond in one. That's just a panelist who says, listen, I'm not going to put my hand on one, tip the scale one way or the other. But if you're a complainant and you had every right or every opportunity here to provide all the evidence to win this case, the registrant didn't reply. Lucky you, but you still got to do your job. And Charlie felt like they didn't. Before we get to our two final cases, I want to say tomorrow we're going to go off the rails. We're going crazy, like on a crazy train. Tribute to you-know-who. Okay, so it's tomorrow, 10:30. This is Wednesday the 20th, 10:30 a.m. Pacific, 1:30 p.m. Eastern. There's the Internet Commerce Association Summer Social Zoom call, where we all get dressed up in our bonnets like we're going to the Kentucky Derby, and we get on a FaceTime. It's a Zoom call, and we all show each other our faces, blemishes and all. Okay, so you don't have to show your face if you don't want, but you do have to be an ICA member. If you're not, you want to join the call and say, hey, I want to rub elbows with some of these people. Contact Kamila, Kamila. That's how you spell her name, Kamila, at internetcommerce.org. And we just have it's a bunch of us members, probably be at least 50 on the call tomorrow. But we hang out, we talk about what's happening in the domain space. And there's registrars there, probably some people from GoDaddy going to be there, from Dynadot. I hope Todd's going to be around. But registrars, some registry people there, definitely a bunch of domain investors. You catch lawyers, trying to chime in when they think, acting real smart and stuff. We'll get some lawyers there. And who else do we get? Oh, brokers. Yeah, you can bet brokers are going to be there acting like, yeah, anybody. They'll go any place to try to find leads, especially when they know domain investors are going to be sitting around. And there's sometimes big folks in there. And when I say big, domain investors, Braden's on the board. He should be there. All the board should be there, but they now let them get busy and stuff. But anyway, that's the board of the ICA. I say, hold their feet to the fire. They should be there. But anyway, it's a fun call. We hang out and talk. It's just 1 hour. It's Zoom. It's just a bunch of domain investors and other people from the industry, like I just mentioned. So check us out. If you're an ICA member, I sure hope I see you there. That's tomorrow, 10:30 my time, 1:30 on the East Coast. All right, our last two cases for today. Well, this one really got a lot of interest from particular Nat Cohen. Nat was like, he didn't like this decision in this next case, regions.org. I didn't like it either, and I'll tell you why. Well, regions.org, so it's spelled just like you think, REGIONS.org. The domain was registered back in 2001. There's a Regions Bank in D.C. that was the complainant. I know there's several Regions Banks, so I don't know. They didn't even bring this up, and when Jeff, we're talking about with these other lawyers and these panelists, I don't remember anybody bringing up. Just there's a lot of Regions banks coexisting here. Okay, so I know there's more than one, but anyway, this is one out of D.C. They went after this domain registrant, um, Andrea Danola out of Italy. She's living the life, living the big life in Italy, and then she gets this. I'm thinking about regions.org. I've owned this name for over 20 years, and this who is this? It's a bank with a trademark. Filed it. Well, Andrea didn't even respond. So I don't know if she got notified or whatever, but this was a case where this bank files this UDRP, the domain owner doesn't respond, the disputed domain has PPC um, links on the page, and it also says, and the links on the page are for online banking accounts. So you can imagine regions.org, it could have a meaning in a lot of different areas, but the PPC page bothered the complainant because it was, competitors to Regions Bank. It was other online banking uh, uh, companies, so you can open accounts. So the disputed domain name also had maybe for sale on the lander, which, the complainant said that already proves it, that they're just out to, do some bullshit. And I won't say all the facts, leave some to you guys, but the complainant once again said there was phishing emails that have been sent out using alert@regions.org to some of our customers. And I'm going to search while you guys are talking about where does Regions Bank, what domain are they on? I don't know if they're on regions.com. They probably don't even own that one, but they were, complaining
Yeah,
about
they are on
phishing emails.
Regis.com.
They are on regions.com.
Yep.
Lucky them. Okay, David. So they used the phishing, excuse to try to get this name. Tell us a little bit more about, your thoughts on this case and what happened.
So they said that there was phishing, but using a subdomain, alert.regions.org. And I looked that up, and there's no MX records there, either on the top level domain or on the subdomain. So that's false. So it must have been a spoofed email that they captured and presented as evidence in their case. I think that is a gross violation of their duty for competence, technical competence. And yeah, I don't agree with it for that reason. The respondent is based in Italy. The registrar is Sav. I don't know where the mutual jurisdiction is. So I don't know if this guy's going to appeal it or whatever, but regions.org could be a very valuable domain name. It had a BOTUS parking page, but no ads. It just said for sale, and there's like a fill in the form thing. So I guess he was just collecting names and geographic information of visitors, but nothing else. So I can't see any negative uses on the domain name. Did you see anything, Jeff?
No, and I agree with you. And this is one of the dangers of kind of was pointing out to, like, if my case, or especially the Chick-fil-A case would have gone to this particular panelist. This panelist, Deborah Lyons, who is actually a guy, not a, uh, is one of the panelists that is heavily in favor of trademarks, gets default cases mostly, does a ton of them every year, and basically has the view that if a complainant submits evidence or anything, I shouldn't even call it evidence, but submits any alleged evidence, and the respondent doesn't reply, then he's just going to assume it's all true. And that's one thing. And so you're absolutely right, David. There's no MX records associated with this name. It's obviously being spoofed, and people need to know how to use basic tools to demonstrate that that it's the registrant's actual email and it's not being spoofed. And that's really easy to do. Just print out the header information, which every major commercial software email application allows you to do. um, some call it source, some call it header information, but it's all there. And that needs to be submitted. That needs to be minimum if you're going to rely on phishing. But the other thing that's weird about this case is that they like, let's say everything is true and it was used for phishing. Let's just pretend. Um, that only talks about use today or now in bad faith. But under the UDRP, you have to show both registration and use in bad faith. And in the decision, there's nothing to give a clue to us that uh, the panelists considered whether the domain was registered in bad faith back in 2001, right? Was it July 4th or June 4th or something like that? 2001. Um, there's nothing in the decision that points to whether this was even considered. So that's another issue. So the two issues I have is one, there's no demonstration of registration in bad faith, and two, what they're relying on this phishing is just not true. So yeah, this decision is a problem from a number of different levels.
This was a transfer, if you guys were wondering. So this person owned regions.org, regions.org, for over 20 years. The domain was transferred away. They didn't respond, and Mr. Deborah Lyons, who was the panelist here, said, "Okay, well, this Regions Bank has a trademark, and they did make a case, and there was no response. So they didn't. This respondent domain owner didn't show what they were using it for. It was on a parked page, and passively holding a name doesn't mean that not always considered legit use. And it said maybe for sale. But what Jeff brought up and what Zach brought up in comments that he made on the Internet Commerce website, because they review UDRPs, they have a UDRP newsletter each week. And this was the case that they looked at. And Zach said exactly that. Like Jeff said, the panelists did not even address the bad faith registration issue. They only addressed the bad faith in use. So you have to address both. And Zach said it. Don't conflate the two. Right. There was no evidence that this domain was registered in bad faith. It was July 4th, 2001. When they registered it, was their intention? Were they targeting this particular organization? And would there have been any other reason to register the name regions.org? Well, of course, you can just think of it. But I think because this respondent had a mixed history with the UDRP, losing some names. They've been around for a long time, that this panelist held it against them. But anyway, Nat Cohen was also, frustrated by this decision, because he brought up what Jeff brought up. This phishing, it could have been somebody else, not the domain owner. You can't prove, or you guys didn't prove and provide evidence that the domain owner was the one that was doing this phishing. And even if their name was involved, and then of course you didn't even address the bad faith registration. So that's a pretty big deal when it comes to a domain name. So really felt like this was just not a good decision, because it didn't have solid reasons behind why they ruled that there was bad faith registration. And then, and then Jeff mentioned too, panelists need to understand phishing capabilities that crooks have in many of the different things that they do, different ways that they fish. And many times they'll use a domain name that they don't own. So if they don't own it, somebody else owns it, and that somebody else shouldn't be responsible for the actions of a third party, of a crook. All right, so that was a transfer, regions.org. So sometimes you're out there, you think you got a good .org, and I'm looking at a .org right now, drop catch. Anyway, that was a transfer. We'll get to our final case and get out of here. Case number 4, elizabethtaylor.ai. I love her. I love her a lot. Anyway, she was an actress. She died in 2011. Okay, so her trust was part of as one of the complainants. There was 2 other companies. This one, I forget what it was called, Inner something Productions. I don't even know what it was. And then Elizabeth Taylor Cosmetics. So it was another example of they all 3 really had standing here, because one company owned the trademark and owned the rights, and then licensed it out to 2 different companies for different things. But primarily, the complainant was licensing the name for cosmetics, perfume, skincare, and that's what those two other companies were selling. So the respondent once again didn't reply in this case, and the respondent really, as Jeff mentioned in his case, that he decided the respondent in that case had made no preparable demonstration of using it in some legit fashion or in a bona fide way. So that really was held against the respondent in this case. They not only did they not respond, if they did respond, they would have need to shown here's why I registered elizabethtaylor.ai, which was just registered less than a year ago, September 15th of last year, and so the the panelists said, well, the complainant basically said, look, they got these PPC, it's a PPC page, and they're benefiting. It was weird. They're benefiting off these links, but the links were unrelated to the complainant's products because the links were, I guess, male perfume and some other products. They seem to be really close related to me. So I thought it's pretty close, but it was a GoDaddy PPC page. So first to you, Jeff. So this seems like just one of those default GoDaddy PPC pages. The panelists said, I believe that they're probably making money off this, but I didn't see it that way. What were your thoughts?
Yeah, well, first thought is, we've seen personal name cases before under the UDRP, and in order for those cases to be successful, they must have a trademark. And in this case, they do. They have several trademarks, so they're not relying on common law marks, but actual trademarks. Elizabeth Taylor, as you said, was extremely famous, at least in the United States. Beautiful violet eyes, for those of you that remember, um, and is an extremely well-known brand of jewelry and cosmetics, I think. Um, but you're right. In this case, the evidence of bad faith was the fact that it pointed to a GoDaddy parking page that had PPC links on it. So yeah, this is another case where GoDaddy got its customer in trouble and was the result of this person losing, the respondent losing the domain. I kind of think, look, I know it's hard to imagine unless the person's name is Elizabeth Taylor as the registrant, or that Beth Taylor or something like that, which it's not, at least according to the Who Is records. It's one of those names that's so famous it's hard to imagine a use that wouldn't somehow conflict with Elizabeth Taylor. So at the end of the day, this respondent probably did not, probably registered in bad faith, but that's not the test, right? You have to provide actual evidence. And the evidence that was provided here, the actual evidence was the result of GoDaddy. And unfortunately, um, we've said this many times on this podcast over the years, and I've raised this with GoDaddy on a number of occasions. They won't stop pointing these things to their own PPC parking pages, and although you go to the parking page and it very clearly disclaims liability for GoDaddy, saying GoDaddy's not responsible for these ads, it also does not say, like it should say, that the registrant is not responsible for these ads and not getting any financial remuneration for these ads. But GoDaddy would rather have people blame the registrant than themselves. And sorry if that comes out against GoDaddy in terms of my judgment there. But I think it's awful that GoDaddy does that and can remedy it by just putting, the same disclaimer it has for itself for the registrant. And it won't, because it would rather leave third parties with the impression that it's the registrant putting out the registrant is the source of these links, and it's the registrant getting paid as opposed to GoDaddy getting 100% of the payments and GoDaddy selecting the company that provides the search results. I just think that's wrong on so many levels, and it left this panelist um, under the impression that the registrant was likely making money off of it when we all know clearly that's not the case.
Yeah, and I think that reflects negatively on the panelist's technical competence. He has a duty to understand these things and refuses to learn about them. And clearly, GoDaddy does not pay anybody for any domain names that are registered there that are parked, unless they opt into cache parking, which does not have GoDaddy branding on it. It's a totally different thing. But when I went to the site, I didn't see any ads. I just saw listings for auctions coming up. So I don't know, maybe it's targeting people based upon who they are and where they're coming from.
Yes, I meant to say that too. I had the same thing, not auctions, and I can't quite remember what it was, but it was not um, anything to do with um, not anything to do with Elizabeth Taylor.
The panelist
So,
here. Go ahead.
as an aside, so this registrant is based in Florida. Elizabeth Taylor died in Los Angeles, and people who had a commercial persona and died in California have a right of publicity that goes beyond their death for I think 70 or 80 years. But there are still ways to monetize these kinds of sites. I remember growing up, every time I go to the checkout counter at any grocery store, there would be a magazine with a picture of Elizabeth Taylor on there and some scandal showing up. And you know what? That people love to read that stuff. And so, if there was a site that just regurgitated all those old news stories or debunked them, that could be monetized. You could have an acting school on there, like an educational school, teaching how to act the way that actresses, classically did the acting like you'd see on Turner TV. But, because younger actors don't use those same types of acting techniques.
Yeah, David, are you in front of your computer now?
I
Because I
am.
just went to elizabethtaylor.ai and I'm getting a different result than what I got this morning, and it's got no pay per click. So maybe GoDaddy read the decision and decided to change it. I don't know, but right now I'm not
Oh, I
getting
got
any.
pay-per-clicks now. So now I got men's perfume, White Diamond Perfume Canada, and divorce is divorce hers. What?
Oh, that's funny.
So,
That is related to Elizabeth Taylor.
but it
Um,
does say, GoDaddy on the top. It says excellent, 4.6 out of 5, Trustpilot. It has GoDaddy copyright in the bottom. So this is clearly a GoDaddy page, not a
yeah,
cash parking page.
I'm not. I'm getting just a GoDaddy, just a regular page that says this domain's registered but may still be available if you're interested. Try our domain broker service. I don't know why I'm
Yeah, I
getting
got that
that.
this morning. Yeah.
Okay,
So
so
it's
maybe it's
interesting
just
to note
random. Yeah.
the DNS servers are domain control. So nobody with domain control DNS would ever have cache parking. It either has to be Afternic or cache parking DNS.
Right, and that's where education fits in for panelists. And um, you were saying earlier that the panelists should have an ethical obligation or should have a technical competence. The problem is there's precedent out there that this is okay. That I mean, not it's okay. That you don't have to do that. And so it's almost the same as like a court saying you don't have to do that. You don't have to be technically competent in this area because it doesn't matter. Um, so I don't know if it's an ethical obligation, but it's certainly these things that we discussed today about phishing, farming, malware, search engine results, all of that stuff needs to be the subject of educational materials for panelists, and that they should be expected to go one more step and to see and to test whether the complainant has in fact provided actual evidence of what they are claiming.
Jeff, absolutely. Registrars should be aware of all this, but certainly a panelist who's making a decision on a domain name needs to understand when a domain's registered at this registrar, by default it goes to this type of lander. And I was looking at the lander just now, Jeff. I was getting what you were getting, not the pay-per-clicks, but the general lander page. But James Bridgman was the panelist here, and he certainly needs to know that some domains default to, if there's nothing done with them after registration, they default to wherever the registrar decides for them to go to, and that can be a PPC page. And a couple things I want to say is, yeah, so this panelist said on the balance of probabilities, this registrant was receiving revenue. Wrong. Okay, they weren't. We know that. That's one thing they should learn. And then on the balance of probabilities, the domain was registered in bad faith. Well, I can certainly understand them believing that, but I like what David brought up, that listen, there are legal ways to use Elizabeth Taylor, even her likeness, whether it's legitimate news or, and I was going to bring up about the divorces, it could be, uh, different ways legally to use elizabethtaylor.ai. And I think folks are certainly, we're going to see different examples with AI. How can a person use AI with a famous person's name, including their likeness and so on, but stay within legal guidelines? So how can you use AI with a famous person's name or their likeness, but still, like I said, not infringe? So, in this case, it really needed to answer, but there are legal ways to use this person's name, Elizabeth Taylor, and she's certainly famous. Um, but this was a transfer, so if you guys didn't catch on, yeah, James Bridgman transferred this domain away. This person, the registrant lost it. And by the way, tomorrow on the call, when I see Paul or and it's a fun call on the ICA, right? We have fun. It's a summer social. We're all drinking Mai Tais and hanging out, lays around our neck. All right. So when I see Alan or Paul or anybody from GoDaddy, I am going to mention tomorrow, say, hey, yeah, we do this legal show every Tuesday. But yesterday we were talking about these default PPC pages, and GoDaddy has the disclaimer saying we're not responsible. We know. We're going to say it again. Add the domain registrant isn't responsible for these links either. You guys are going to do that or no? I guess my point is, when we're ICA members, that's one of the benefits of going to the meetings, the annual dinners or annual meeting, and even the monthly calls. Why? Because you can talk to somebody about the features on their website. But when it comes to, I'm not doing it in an adversarial way, but still, it's like, hey, this has not been the first time it's been brought up. Jeff, I remember when you brought it up directly. Once again, you did it privately to him, emails to him, but then also publicly at our ICA meetup. And why not? Let's hear the reasons. It's like, I don't want to hear the reasons really. Just want to say, just add it in there. People are losing their domain names because they're being blamed for your PPC pages. So when Jeff, when you asked, add a disclaimer, yeah, it wasn't just a disclaimer for GoDaddy, it was a disclaimer for the registrant as well. So I bring that up because people think, well, geez, GoDaddy pays for dinner when we're at some of the meetings. Well, so does Dynadot, and so do these parking companies and so on. Well, it still doesn't mean that you can't say, hey, what's going on with your service in this sense. And you can certainly pat them on the back too on things that you like. But anyway, tomorrow when we're on the call, I'll certainly remember, because I'm going to think, yeah, we're talking about this stuff. I hate to see a domain registrant. You buy a name, you're expected to, immediately start developing it out in some legal way, which most of the time you're like, I just got the name. I might think of all my different legal ways to use this, and until then, I'm just going to leave it parked, and I shouldn't get in any trouble for this. I've done nothing wrong. I've made no moves. I've only registered it, and especially if you've made no moves showing that you've had bad intention, there's really no way your name should be taken away. But we see They certainly can be. All right, so that's it for today. I appreciate everybody sticking around and listening to me, Jeff, and David. We're, like I said, tomorrow there's an ICA member call, 10:30 a.m. Pacific, 1:30 p.m. Eastern. If you're not an ICA member, go to internetcommerce.org, join it, and we'll see you tomorrow. And then Thursday, of course, me and Josh do the domain DNX show right here on X. That's 10 a.m. Pacific, 1 p.m. Eastern. We got a lot to go over. Hope to see you then. But everybody, until then, have a great rest of your day wherever you're at. Take care.